afternoon, dear professors and dear guests. It is a great honor for us to host you again for the fourth seminar of Comparative Law Seminar Series. Welcome all, and thank you for being with us today. We have very distinguished guests today, our professors, colleagues, and students, and the participation is remarkable. Thank you very much. Thank you all. Today we will listen Professor Sjef with his presentation on the impact of new IT technologies on property law. So this event today is co-organized by Kadir Has University Faculty of Law and Kadir Has University Liability Law Research and Practice Center. Firstly, I would like to give the floor to Professor Ergun Özsunay for his opening speech. Please, Professor Özsunay.
Thank you so much. This is Özsunay speaking. In fact, I am not going to make an opening speech, but just I would like to present Professor Sjef van Erp, one of the most important scholar in the EU, in my personal opinion. Sjef graduated from Tilburg University, and he studied several important centers. For instance, first, he attended Faculté Internationale pour l'Enseignement du Droit Comparé, ESMI, and then the Hague Academy of International Law. And then he continued his studies in Max Planck Institute in Hamburg. At present, he teaches European private law at Maastricht University School of Law. And at the same time, he is very active in Académie Internationale de Droit Comparé and Association Internationale des Sciences Juridiques. Further, he is also active in American Law Institute and particularly European Law Institute. By the way, Sjef is one of the founders of the European Journal of Comparative Law and Governance, at present Electronic Journal of Comparative Law. Also, he is one of the founders of the European Property Law Journal, editor-in-chief, one of the editor-in-chief of the Jus Commune Casebook Property Law, and he is also active in EU Common Frame of Reference Network in the fields of European sales and property law. I usually meet Van Erp on the occasion of several international conventions, so a pleasure for me, of course. I met him in Stellenbosch. He presented an interesting paper to our colleagues from the Association Internationale des Sciences Juridiques. He is also very active and a member of Dutch group of experts to assist the Baltic states, Belarus, Hungary, Mongolia, Poland, the Russian Federation, and Ukraine during the second generation codifications in those countries. So today we are going to hear Sjef on information technology and information technology regarding impact of the impact of new IT technologies on property law, because he is an expert on property law as a comparatist. And as you know, information technology is the use of computers to store, retrieve, transmit, and manipulate data or information. So a very important area now. By the way, I participated the Ancestral Working Group 6 works on secure transactions. We have more or less met the same issues regarding information technology, and on the occasion of the establishment of an electronic registry. So now I think this presentation will be very much important and interesting. Then again, I thank all organizers, by the way, to grant me to present my dear colleague Sjef Van Epp. So that's all. Thank you so much.
Well, Professor, thank you very, very, very much for your kind introduction. And yes, we have known one another for quite a long time, and it's a pleasure meeting you again. Although online, it would have been much better in person. So let me see. First, start sharing my screen. There we go. Okay. Right. Now, the topic of my presentation has to do with digitalization as such. And the focus is on land registration, but in fact, I use land registration as an example to be more concrete, because otherwise it all remains fairly abstract, and it is difficult enough. Let me say a few words about my background so that you understand from which academic background I'm discussing this. I think about, what was it, 23, 24 years ago, I was appointed at Maastricht University to develop research and teaching in the area of comparative property law. And so at the beginning, I taught on, well, common law, civil law, differences between civil law, countries, and so on. Comparison, yes, but not too much. And then suddenly, some 15 years ago, the world changed. We were in the middle of the financial crisis. There was this paper on Bitcoin, so digital coins, smart contracts came up, and suddenly all sorts of questions arose, for which basically I think most of us as lawyers were not prepared. And so let me discuss this based on focusing on land registration as an example. Now, historically, land registration is information management because it is about, well, who owns which plot of land, who has a particular right regarding that plot of land. And so what a land registry does is give information to others about who claims a right against the world about a particular piece of land, a particular immovable. So it's information management. What we then see, but I'll discuss that further, is that this information management in the beginning was very, how to say it, physical. We had ledgers, so big books, handwritten, in which it was stated where a particular object was, who a right had, and so on. And then that was digitalized, and now it gets virtualized, and I'll talk about that as well. When doing that, I will analyze the questions that we're faced with in a very traditional way, because what we're talking about are rights that a particular person, a subject, has against all other subjects concerning an object. So we work in a triangle. We have a subject, other subjects, an object, and a right. And it's on that triangle that land registration is based. But it's also that triangle that we need to analyze how we should look at digitalization and virtualization of our reality. When I get to that point, I will discuss 3 scenarios with you, how the more traditional land registration can be connected with digital and particularly virtual registration. I will discuss briefly the risks and how to limit those risks, and then some final remarks. But at the beginning, I would like to say this. Recently, two colleagues of mine in Spain published a really good paper on digitalization of land registration as we now see it. And they were discussing that now we no longer have these written ledgers, these big books. We have computers, we have databases, servers, data centers, and so on. So the description of the object is digital. The description of the right is laid down in a database, so it's digital. Who has the particular right is also laid down in a database, so it's completely digital. And what these colleagues did was say, well, now we have other developments like blockchain, smart contracts. I'll say a few words about that so that I'm absolutely sure that you know what I'm talking about. And you know how to fit these developments into what we already have. But a problem is that the software developers working on or with blockchains and smart contracts, which I'm going to explain to you, these software developers are not interested in the law at all. They're interested in running a system according to preset computer code. And you know, there's a famous author writing about the impact of IT and law, who said that, well, you know, computer code is the new law. The law is what the programmer tells us. And we as lawyers, we think differently. We say, no, the law is what a legislature, a judiciary tells us what the rules are. And we apply that to what we see happening around us. So two completely different visions on the relationship between IT and law. And what I will also try to explain to you is that the vision of the lawyer, even when we look at digitalization, is not really the vision of the IT developer. And an IT developer, when developing a virtual reality, is completely different and is not worried about, well, you know, does my computer code fit into a numerous clauses? That person will look at you and say, numerous clauses, what are you talking about? It's my code. It's not your code. It's not your civil code. It's my computer code. It's a very different way of thinking. And we as lawyers will have to face that. We will have to understand what is going on. We have to understand these differences in approach. So let me walk you through all these points slowly. In case you have a problem understanding me, please do interrupt me, because I will build one step on the other. And yes, it really is very complicated. Now, traditional land registration is aimed at mirroring what we see as reality, so that we lay down in a registry, okay, this is the plot of land that we are talking about, this is the house we are talking about, and this is what we describe in our land registries. So the registry mirrors reality. And historically, this was handwritten ledgers, maps, and so on. Then we began to digitalize this, as I already said in the opening words. We made it possible that everything that was handwritten is now available in the form of data on a computer, on a server. The map is now a PDF, and so on. So we digitalized information, but the idea still was that the digital information still mirrors reality. It doesn't really matter whether the notarial deed in which I transfer my house to someone else is a handwritten deed or a typed deed or an electronic deed. It doesn't matter. It represents that I transfer my house to someone else, and that is registered. So digitalization is not aimed at changing the law. It is aimed at changing the format of the law, the form, not the substance. So we digitalized the object, we digitalized the right. But what we also began to realize was that by digitalization, by having it all available in the form of data, we could do much more than say, well, you know, this is a deed of transfer from A to B, so let's register it. We could, in fact, now start analyzing that information, because a land registry is, and that is how I started, is information management. You manage information about land, which land, who owns the land, and so on. So we began to analyze the data. And that is a possibility that I think traditionally land registrars did not realize. They only discovered this at the moment that in countries like Canada and Australia, governments were also beginning to understand that, you know, data could be analyzed, were valuable, and could be sold. And it is this realization that made the privatization of land registries in Australia and Canada possible. In both countries, land registries have been sold by their governments to investment funds. That it would be unthinkable only 20 years ago, that we would sell a land registry, which typically would be a government agency, that we would sell it to an investment fund. Why would an investment fund be interested? Well, they're interested in the data, in the form, because the form makes analysis, data analysis possible, from which you can gather further data, and those further data are valuable, can be sold. But that is one development. That still is digitalization and the consequences of digitalization. We still look at land registries, although now in digital format, as being formalized and static. So the object is there, the land is there, the house is there, the owner is actually there. But then the so-called fourth industrial revolution came. So we developed distributed ledger technology, and I'll explain that really briefly, blockchains, smart contracts, and so on. First, distributed ledger technology. That is technology, software, that makes it possible that you register who owns a particular electronic document, and that every computer that runs the same software also registers who has which document. So it is an old style ledger, an overview of who owns what, but a ledger that, as a result of this software that all the participating computers share, a ledger that every computer has. So it's a database on every computer, and the moment one of the computers changes the database is changed on all the other computers. So there is constant synchronization going on there. So it's a ledger. It is distributed over all participating computers using the same software package, and there is constant synchronization. That technique was used to create documents, blocks, that once when they have been created cannot be changed. So we all know a Word document, once when you make it, you can open it again. Even if you locked it with a password, you can open it as long as you know the password. But a block cannot be opened. And the developer of this particular type of distributed ledger technology, the developer of Bitcoin, because that is what I'm talking about, said, well, let's suppose that, you know, we can put in the document the text "I am money," and we put that on a distributed ledger, And we add to this that only the person who is registered as owner can transfer it. And how do you decide that? Well, if you want to transfer your block to someone else, you have to ask permission to all our other computers in the system. And if these computers say, yes, we have in our ledger that he has this particular document, it transfers. If I want to do this again, because the big problem with data is you can copy it. You can copy it forever. So suppose I copied that document. I cannot open it again, but I can copy it. And suppose I would try this again. Then the computers would say, well, in our ledger, it says he transferred it. And you can only transfer it once because this is how we are programmed. So what blockchain technology did, added to distributed ledger technology, is make it impossible to transfer a block more than once by the same person. And in that way, the block becomes unique. And uniqueness means scarcity, and scarcity in economics means it gets economic value, and that is the value of a Bitcoin. Now, then the transfer that takes place, so how you transfer the block from one to the other, the transfer that takes place is also governed by newly developed software called smart contracts. And the smart contract has nothing to do with contract law whatsoever. It's a computer program that once when you start it, you cannot stop it. It executes automatically. So the block is transferred as a result of a self-executing program. So once when you say, I want to have this transferred, the transfer takes place. And the transfer is also laid down in such a block, is registered, is archived. And this archive is added to the block that you transfer. And this creates the blockchain. Now, I can tell you, in the world of land registrars, where they want certainty and absolute reliability, that you transfer this object from that person to the other person, this sounded ideal. So the idea was, why not put the object in a block to describe it as part of a block, and why not make transfer of a block of that particular object of ownership possible by using blockchain technology in combination with smart contracts. The article that I just mentioned, written by my Spanish colleagues, is precisely about that question. What happens in case you put everything that we now have in a digitalized land registry into the format of blocks based on distributed ledger technology, where the transfer in the system takes place as a result of a smart contract? Experiments have been going on in this area worldwide, and so far not really very successful, but there's more going on. And if you already thought that this sounds revolutionary, what I'm going to tell you might worry you even more, and it should worry you. So what we see here is no longer a static registration that we see in land registries, but a code-based, a computer code-based dynamic registration. That is what distributed ledger technology, blockchains, is all about. And you can understand that if you use this software, which is aimed at dynamics, at changing, if you want to combine that with a registration system that is aimed at creating stability, a static reality, there is a conflict. We have all sorts of questions here. I simply do not have the time to discuss that with you, but I can tell you in comparative legal literature worldwide, the question has already been asked whether a computer could be a legal subject in this system. Like, you know, we have legal persons, corporations. Could a computer be a sort of corporation? It sounds science fiction-like, but don't forget, at big exchanges, where they deal in stocks and bonds, that's completely automatized. It's computers trading with computers. You come really close to this. The object here is always data. But, you know, if you want to regulate data, if you want to regulate what is happening here, and I can tell you, countries are struggling with how to regulate this, because this, what I'm now explaining to you, this is the world of software developers, not the world of lawyers. This is happening. And we as lawyers, a few years ago, were looking at this like, no, this cannot be true. No, we're going to deny this. This is not happening. It is. And so how to deal with this? I have to go one step further. And I'm sorry, I know this is difficult. And I know I don't have much time, but I have to take you one step further. So where we began was land registration, handwritten. You know, you have a description of the object, you have a big handwritten ledger, A owns plot, whatever. Digitalization. We all put it down to data and we have it on a computer, but still the aim is we now have in electronic format the object and who owns it. And given that we have it in electronic format, the question comes up, well, you know, we have these new technologies. Can we use these new technologies? Because we brought everything down to data. But it goes further. You see, what is also possible is that you do this. And I'll give you a real life example, a question that I was asked 3 weeks ago. In the Netherlands, we have so-called water boards from the Middle Ages. So they are old public law institutions to take care that the country keeps dry. Because if we don't do that, 2/3 of my country would be underwater. So when you land at Schiphol Airport, technically you're 3 meters below sea level. So these water boards take care that, you know, there's good water management. Now they own a sewer system. This particular water board also owned a sewer system. And because of all sorts of developments, they had lost ownership of their sewer system. Now, in practice, that is not a problem because everyone has an interest in the water board running the sewer system, but they wanted to create legal certainty. And the question to me was, well, you know, our sewer runs through the land of I don't know how many farmers, how many local councils, public authorities. So strictly speaking, we need to go to all of them and ask, are you willing to create ownership of that particular part of the sewer system to us? You know, the rule of accession, right? You own everything. When you own the land, you own it above and under the land. So all these farmers and public authorities could say, we own a part of the sewer system. We have to go to all of them. And they asked me, can we do it this way? That we describe in the form of a digital description of where our sewer system is, that we then create let's say a software based on distributed ledger, on blockchains and so on, that we write to all these farmers and these public authorities, whether they are willing to cooperate with us in setting up a software system in which we describe our sewer, the whole sewer system, and we then create for each individual farmer and for each local council a block describing which part of the sewer system is on the land of that particular farmer or on the land of that particular local council. The blocks in that computer system are then given to the farmers or to the local council. And then, with the help of smart contracts, they all transfer those blocks to us as the water board. Did you hear me say, let's go to a notary and have a notarial deed? No. What you heard me say is, in the land registry, nothing changes. What we do is, we create a digital, I would say a virtual reality of each part of the sewer system, depending upon, farmer A, farmer B, and so on, local council A and B. So we create a block which describes that part of the sewer system. We attribute that block to the particular landowner. And in this computer system that we will create, then the block is transferred to the water board. So the water board now has all of the blocks and now owns the sewer system again, but not in the land registry, but on the distributed ledger, virtually. Well, if you do this, and I can tell you, this is already happening. I can also tell you that I told the particular water board not to do this. That it sounded really interesting, and as an academic, I felt very much attracted to the idea of trying it out. But thinking in a more practical way, I said, don't do this. So they're not solving it in a more traditional way. But it is already happening. What you then do is, the block that you create is being called a token. A token is simply another word for block. And the token is registered in that computer system using that particular software package. And the token is transferred. And what we now see is that there are already, in a way, experiments going on where the token is representing a physical object, so the sewer system, might be representing who owns it, the traditional real right. But a token can be anything. The token could be, for instance, well, you are entitled to only use the sewer system. It could be anything. It's like you, as a project developer, you develop a block of apartments, but you do not register in the land registry each apartment separately. You remain, according to the land registry, the sole owner. But everyone who wants to buy an apartment from you, you give a token. You make that person the owner on the distributed ledger. It's the same approach. And that could be a traditional right of apartment. It could be anything that you agree on with that owner, as long as you code it into this particular block. So basically, you can step over the whole law of property. You can ignore the numerous clauses. You can ignore how we create real rights, how we transfer real rights. You can ignore how we describe objects. The problem, of course, here is what happens if things go wrong in the land registry, in the traditional land registry. So in my last example, suppose the project developer sells and transfers the land plus the building to another person. And another person looks in the land registry and says, well, it's a plot with an apartments on it, that's it. Can the new owner then go to everyone living in those apartments who live there because they have a token, can the new owner then go to the token holders and tell the token holders, go out, go away. You do not have a real right because you're not on the land registry. What is your right then as token holder? Those are the problems that, in fact, I'm dealing with in the research that I'm doing right now. What is the position of the token holder in that situation compared to the tradition, the position of the traditional, let's say, landowner according to the land registry? In tokens, words like ownership function like management tools, but they're not rights. So we can do several things here when we analyze this. And you might say, well, you know, this is futuristic. It's not happening. It is happening. And fortunately for us, and I would say for most of us, most of our citizens, not too much, because we have serious legal problems to solve here. But I can assure you it is happening. And then we will have to face the legal reality, what we have to create as legal reality, according again to, well, who do we accept as subject of the right? What is the object of your right? What is your right? So it could be an actual right regarding a physical object, as long as that is in digital format on the land registry, it doesn't matter. If it is an electronic deed that is registered, that's okay. But if it is a token only registered on a distributed ledger and invisible to the land registry, we have a problem. So we can have a registered right regarding a registered object. If the data mirror the reality, that's not a problem. So as long as blockchain technology and smart contracts are used by land registries, basically to streamline the whole conveyancing process, then it's not a problem. But the moment we start creating virtual objects which are not in conformity with the real object and virtual rights, then we are faced with the problems that I just described to you. A water board that has tokens, but is not the owner of the sewer system in the land registry. Apartment holders who have tokens, but the project developer is the only owner, again, in the land registry. What is the position of the holder of the token? So this is an overview. If you want to, I think I sent my PowerPoint already, but you're free to have it. So the question that I'm faced with is, how do you connect the existing land registries that we have with what is happening right now? And in fact, I could also ask the question, how do we connect existing financial arrangements, financial security rights, mortgages, pledges, transfer of ownership for security purposes? How can we connect that with fintech, financial technology? It's the same question, but I'm focusing on land registration because I think that is more concrete. Like first, the first approach would be we deny everything. Land registries do what they do. They are now mostly in Europe digitalized, so that's it. No problems with property law whatsoever. Well, we have to recognize electronic deeds, but that is generally accepted. If you do this, you create the problems I just described. because it would mean that token holders have nothing to argue on that they could stay in that apartment. The water board has no argument to say, yes, but it's our sewer system, because according to the land registry, it is not. And tokens is something invisible, binding those who take part in the distributed ledger. But if you're outside the ledger, you're not bound by it. You don't know about it. Why would you be bound by it? What you could also do is that the land registries start adding to their information an overview of what they know about the data available regarding that particular piece of land or house. And some land registries are already working on what they call a digital passport. So for instance, data about the fertility of the soil in case of farming land. But you could add a virtual passport to that and say, well, we as land registry, we know that tokens have been issued regarding this piece of land, and you can check with us what the token is, but it means that the land registry must be one of the computers in the system, because otherwise you cannot see what the token is. You can only see the token from the inside of the computer system. Or, and that is already happening, the computer system itself is registering. And that we already saw in the United States, in MERS. MERS is Mortgage Electronic Registration Systems Incorporated. It is a private company set up by banks. And the way nowadays you create a mortgage in the United States is you go to a bank. If the bank will give you a loan, you will have to give the bank a right of mortgage. But then the mortgage is registered in the traditional land registry, but not in the name of the bank, but in the name of this private corporation, in the name of MERS. And I've been told, I already knew that about half of the mortgages in the United States is now in land registries registered as a mortgage by MERS. I've been told that it is now even 70%. So in 70% of the cases, when you check the traditional land registry in the United States, you see that the mortgage holder is MERS. Who actually is holding the mortgage, so which bank at the end wants to enforce it, you only know when you get into the computer system that MERS runs. You have to be inside the system. Now, this is not token-based, but it is a model that could easily be used to solve token-based problems. But at the same time, you must have access to the computer system. And why did they develop this in the United States? Well, this was developed, I think, some 25 or so years ago, because by registering MERS as the holder of the right of mortgage, they made it possible that within the MERS system, mortgages could be traded among banks electronically. It made electronic trading possible. Because otherwise, in case the holder of the right of mortgage changes, you have to make the change in the land registry. That takes time, it costs money, but doing it in a computerized, automatized way makes it much easier, and it doesn't cost so much. So this is a development already going on, and it might solve problems around tokenization. Now, it will be clear, I hope, that this development is a grave risk for what I would call an innocent citizen. So suppose you would actually buy a token thinking, well, you know, looks good, sounds good. You don't have to go to a notary. You don't have to pay the fee of a notary. you don't have to pay the fee to the land registry. So, but then what do you get? Because the legal position, the legal status of a token holder is not clear. I would say, first of all, we need to know what are the rights of token holders, and in my example, token holders regarding immovable property. What are the rights of the token holders with regard to the rights that are registered on the land registry? Until now, I can tell you one thing. If my advice would be asked, what is the right of a token holder? And I would say, you are completely unprotected. Maybe there might be a case to assume tort liability in case incorrect information was given. But I'm afraid that the starting point is you're lost. And is that what we want? No. Before we start using this technique, and what I said, already experiments are going on. I would say use sandboxes, test it first, and don't try it out immediately, because then things can go horribly wrong. And I would say we should strengthen the surveillance role of anyone involved in surveillancing, the conveyancing of land. So notaries, land registrars, but perhaps also banks, because tokenization will involve financing, and that we say, well, to banks, you cannot cooperate with financing tokenization, for instance, in the case of a consumer or in the case of a token regarding immovable property. So what do we have? What we see in land registration, but also elsewhere. But as I said to you, I used land registration to make it more concrete. Although I understand in 40 minutes, I cannot explain everything. We are already working on the basis of digital by default. So handwritten documents in the European Union, you just don't see that anymore. It's digital, completely digitalized. But on top of that, we now see a development towards virtualizing things, creating a virtual reality as a layer over the physical reality. We should understand what is going on, because I explained to you in a few lines really a little bit about blockchain and smart contracts. But I can tell you, I am co-reporter for a European Law Institute working group on how to formulate principles, governing legal principles about blockchains and smart contracts. And we are really hesitant presenting our report. We will do it probably in the course of September and October. But it is technologically so complicated. And the moment you write something down, technology changes, advances, and your rule no longer might make sense, that we're really careful here. But the starting point is you must know what you're talking about. I did not talk about artificial intelligence. You can say to me, well, yes, everyone is talking about artificial intelligence. Yes, but these smart contracts, in a way, are intelligent. Data analysis is more and more complicated, and that is what they call artificial intelligence. So data become more and more valuable. And the more value, the more software developers, investors will be inclined to say, well, what can we do? What can we do with data? And when lawyers, property lawyers, then say, yes, but stay within the limits of property law, please, because property law developed over the ages to protect, let's say, an owner, but also others. I've been talking to software developers working in that area. They're usually in their 30s, and they just consider lawyers to be troublemakers. right? It's a difficult discussion. I can tell you that. But the financial interests here, when we talk about immovable property, are so high, we must do something. But it begins with understanding and analyzing. And I can tell you only this morning, I had another meeting with one of my PhD researchers in this area, who actually worked as a blockchain consultant. Although he knows what he's talking about, when it comes to the legal qualification, he's sometimes very much in doubt. And the moment he finishes a particular paragraph of his thesis, he has to rewrite it because technology advances. We should also understand that we cannot control everything. These issues happen, these problems happen outside your jurisdiction. And you can have extraterritorial legislation, but can you enforce it? And we should also understand it happens in a code-based world, a computer code-based world, a world we do not see. This is what I wanted to explain to you in about 40 minutes. And I can understand very well if you would have an avalanche of questions to me. And perhaps the first question could be, could you explain it again, please? So thank you very much for listening.
Thank you for your presentation, Professor Van Erp. Now, as Professor said, all are welcome to share their questions, comments, and contribution. You may write in the chat section, but also you may raise hand and ask orally your questions as well. I would like to remind that we have reserved 20 minutes for discussion, approximately, 15 and 20 minutes. And Professor Pınar Çağlayan Aksoy is raising hand. Please, Professor.
Thank you very much. Thank you very much, both Bilgi University, for organizing this event. And thank you very much, Professor Van Erp. It was an honor to listen to you. I listened it from the beginning to end. I didn't want it to end. I could have listened to you for another 40 minutes really happily. Due to the lack of time, I would like to very quickly elaborate ask you two main points, if you could kindly elaborate. The first one is about sandboxes. What do you think about the current situation of the sandboxes? How do you evaluate them? Do you find them enough, or how could they be better functioning when we create a sandbox to understand how the system is going to work? And my second question is, what are your projections regarding the functions of the notaries? Are they going to disappear, or will they have a different function? Thank you very much.
Okay, thank you. Both are really good questions. But the sandboxes. Now, sandbox means that you can develop tokens or distributed ledger in a safe environment. So you're not really bound by very strict rules. You can test drive them. And as far as I could see, the sandboxes that I know of didn't really work very well. Because companies are hesitant to test drive. And also because you do not want to create a completely free space. You still want to regulate the sandbox to some degree. And so that goes against the whole idea of a sandbox. At the same time, if we do not allow, let's say, for instance, banks to test what they want to do, how do we ever gain experience here? How do we know what the actual problems will be? So I would say I'm still in favor of sandboxes, but the sandboxes I know didn't really work very well. Notaries. I can tell you that when I started giving talks about this, let's say about some 10 years ago, because that is when these developments started, most notaries interpreted what I was explaining as that I wanted to do away with notaries. And that is definitely not the case. I think it is really good that when you, for instance, buy a house or get a loan and have to sign a mortgage deed, you go to an expert who tells you this is happening, do you know what you're doing, who checks whether the seller, for instance, delivers to you, transfers to you an unburdened house, and so on. What I do see happening is that the old style notary is disappearing. Nowadays, notaries must be very much aware of digitalization. They must know about digital signatures, about various types, strengths of digital signatures. They must know about tokens. At the same time, they should not forget how it was. And I'll tell you for a reason. I think 2 weeks ago in the Netherlands, one of the companies that manages the whole digital management of notaries' offices was hacked. And so the connection between them and the land registry had to be cut to make sure that nothing would go wrong in the land registry as a result. So they had to do it again in an old-fashioned way, deliver deeds by hand. And they just didn't know how to do that. I would say notary, the profession of a notary will change. It is also expected generally that much of the work, which is, how to say it, standard, can be standardized. I know that in the Netherlands, about 70% of all deeds or transfers is completely standardized and is dealt with by our land registry, no longer by human beings, but by the computer system. That means that in that sense, notaries no longer fulfill that primary role that they had. But for the other 30%, they do fulfill that role, the complicated cases. And land law is far more complicated than computer programmers think. So it's a bit of a long reply that I gave you, but your questions are both what I said are really, really good. So I do see a role for notaries, but a changed role.
Thank you very much, Professor. Thank you very much, Kadir Has University, for this great opportunity. Thank you.
Thank you very much. And I would like to read a question from the chat section. Professor Evgeny Popov, a colleague from Moscow State Institute of International Relations, he is asking, do you believe the future of proprietary regulation for social networks processing user personal data is becoming more a public law gravitating domain? Do you see compelling evidence of the limitations that private law provides for proprietary rights of social networks to process and use data? He asks.
Yeah. What you see worldwide is the question, the right that you have regarding data, is that a private law right, a public law right, or is it a mixture or a new type of right? So, for instance, certain data could be personal, and then you have privacy protection, which is public law. But you could voluntarily waive your rights and say, well, you can use those data, and then the data can be sold, and then it becomes private law. In reality, what you see happening here is a mixture, because the data that are sold, those data are still limited by the public law rights given to an individual citizen. Because, for instance, under the European GDPR, so the General Data Protection Regulation, you can withdraw consent. So your public law status, so to speak, is part of the right that is then used. And I can tell you from, let's say, well, discussions that I have and projects that I know about, that is sometimes really problematic. For instance, when you are analyzing medical data to develop medicine. So if a patient cooperates and says, okay, you can use my data, if then afterwards the patient withdraws consent, but the data have been used combined with other data sets, and then finally resulted in data that was used to develop a certain medicine, you cannot undo that. That is de facto impossible. The medicine is there. You cannot say we no longer use that medicine because patients withdrew their permission. And then all sorts of questions come up like, well, it's a public law consent that you give that data can be used, but then the data are sold, and that is private law. But what you sell is the data governed by public law. And the outcome is both, and I found it really intriguing, both in European and American scholarship that I saw, but also quite interesting in Chinese scholarship, that you argue that in the case of data, you have to talk about data rights, and data rights are not private, not public, they are a mixture. And what exactly a data right is depends upon the type of data, the person involved, the persons who have a copy of the data, and the reason why they have a copy. And it's this sort of problem that I myself wrote about. I wrote an article on who owns the data in a coronavirus tracing or tracking app. And then you hit exactly these questions. So the answer is, well, we are moving from private to public, but in a way also from public to private. It's a whole new area. I think we see that next to traditional private law, we already had intellectual property law. I think we now see coming up an area that you might call data law, and with its own rules and its own analysis.
Thank you very much, Sjef. Yeah.
Pleasure.
Thank you very much. And Professor Şener Oktik has a question. I will read it. He says, "Dear Professor Van Erp, could you please give your thoughts on protections of IPRs for industrial designs? Thank you," he says.
Well, that is intellectual property law, and I'm definitely not an intellectual property lawyer. The problems that we are faced with are not so much the problems of, well, the copyright regarding software, for instance, because everyone agrees there is copyright there. The problems are particularly about what you call raw data. So let's say when I drive my car, I do not have a Tesla or anything like that, but I have a fairly modern car, and in that car there is a small computer chip that registers how my engine is doing. So by driving my car, that chip collects data about my car engine. Those are raw data. There's nothing, say, innovative about that. No one has a copyright. But I can tell you already questions are coming up. Who owns those data? Is it me? Because I drive my car, and so I produce the data. Is it the car maker who makes the car in the engine? Because they allow me to basically use that car. Who owns those data? And that is not a question of intellectual property law. It's a question of who produces the data, who makes the collection of the data possible, and why are the data used. Under EU law, for instance, we already have legislation that forces car manufacturers to share those data with the garage when you bring in your car for maintenance. So when I bring in my car for maintenance, and it happened to me, and in the beginning I had no idea why, but I had to agree with my garage that they could read out the data, because they say, well, suppose it ever becomes a case that this is personal data under the GDPR, we would have violated your right to privacy. So to be absolutely certain that we can read out the data, we need your permission. But I also, by law, have the permission to use the data from the car manufacturer, because otherwise the mechanic cannot check the car, cannot repair it. You know, these cars nowadays are so full of computer chips, data, whatever, that, you know, without access to the data, they hardly can do anything. So I'm not saying this to evade your question, but the main problem here is, and I can also tell you that from other projects in which I'm involved, is not so much intellectual property law, it's raw data.
Thank you very much, Professor. And there is a message from Professor Elina Musteira, actually. She says, congratulations to Professor Van Erp for his extremely interesting lecture, and congratulations to Professor Başak Baysal and all the organizers of the most interesting comparative law seminar series. Thank you very much, Professor.
Thank you.
Yeah. And there is also another question from Professor Argun Karamanlıoğlu. He says, thank you for your informative presentation. Build registration on a DLT, or in particular on blockchain, may also bring different issues, as you pointed out. Would you be kind enough to share your opinion about possibility of privacy breach in this scheme, as chains in the blockchain shall access to private and sensitive data of third parties? Thank you so much. He said.
Yeah, that of course is a major problem, because all the data on a blockchain is there forever. At the same time, already software developers are looking for solutions here, so that certain data are not visible, but only specific data, or that certain data are only visible for some people and not for others, or that certain data are only visible for a particular period. So I've been told that, you know, you could simply code it in. I don't know if that is true, but that is what they tell me. So there definitely is a privacy problem here, but that privacy problem is tackled also from the technological side. The difficulty, of course, is that if certain information is on the block, it is there forever, and you can add a block saying what is in the previous block is wrong. But the thing is, you will have to read the whole block to come to the conclusion, right? We said A in block number 1. We said, no, it's not A in block number 2. But you only know that after you read all the blocks and you already have the information, which you were supposed not to have because that was privacy protected. So I think the only answer here is that the solution must come from IT itself, technology itself. I think that is the best answer I can give.
Thank you very much. So, okay, Ismail Dede has a question. He says, how to register movables which bounce land in economic way? Is it projected any token could be outweighed the possession?
Yes. Well, as you know, some countries have the possibility to register movable objects. And worldwide, we have that possibility regarding movable objects of great value, like, of course, aircraft, ships, spacecraft. You know, that is what the UNIDROIT Convention, the Cape Town Agreement is all about. You could do that in the form of a token and tokenization, but the token then must really be the representation of the actual object or the actual right. And by actual object, I mean the real object, physical, outside us, and the right as recognized by a legal system. And it should then not be a right that some software developer or some fintech specialist thought interesting as an investment tool. So you then have to stay within the confines of the law as we know it. And I think that is where we encounter problems, because the moment you start tokenizing, it's a free-for-all. You can tokenize anything. In theory, I could, from the Netherlands, I could tokenize Professor Bijsal's house. She would have no idea that I did that, but I could tokenize it, and I could sell the token to any of you. At the moment, her legal status is crystal clear. She doesn't have to worry at all, because it's not on the Turkish land registry, so it has no meaning whatsoever. But we could still create a whole investment scheme based on me tokenizing immovable property in Turkey from the Netherlands. And that would be invisible from the perspective of the Turkish land registry, but also from Turkish, let's say, financial surveillance authorities. We lose control here. We lose financial control here. And that is one of the main worries in Europe of the Commission. And that is why the Commission in Brussels, I don't know if you followed developments, in the past 4 months, I think already published 4 packages of draft regulations on regulating the market in crypto assets, regulating artificial intelligence, and so on. If we do not start regulating, accidents are bound to happen.
Thank you very much, Professor Van Erp. I would like to take one last question, if it is okay for you.
Sure.
Okay, so Fehmi Levent Özkan, please, Fehmi.
Hello, Professor. First of all, thank you for your very well constructed presentation. It was very easy to follow. So I'm a graduate of Kadir Has University, and I'm also a master's student in Maastricht University, and I'm doing the Forensics, Criminology and Law program. So naturally, I'm more interested into the criminal aspects of this issue. So there was a recent scandal in Turkey where a cryptocurrency platform owner basically made very bad financial decisions and also made an elaborate pyramid scheme, which costed the customers around $2 billion allegedly. So in a criminology class, we usually ask, what are the policy implications? And you have already stated the EU has already published around 4 draft regulations or packages. But how do states actually approach this situation? Because I bet some of them will even go as far as banning or restricting trading in these cryptocurrencies or even these tokens. And I think Turkey has recently followed that trend as well, to restrict the usage of cryptocurrencies in certain aspects of trading. So I know it is a very broad question, and you have already said regulation is required, but the question is how, and what are the states doing?
What you basically, and by your question, you take me to my last slide also. So it has to do with jurisdiction and sovereignty and the power to enforce your own law. I can understand a country banning tokens. I can understand that. At the same time, developments go on. And I would say it's a risk that you take, because by banning it, at the same time, you lose control. It's much better that you see what is going on than that you do not see it. Also, by regulating, you might avoid, let's say, experimenting, right? At the same time, you can say, well, under the law of country A, B, C, it doesn't really matter, because the question is general. We do not want this, but you cannot stop it happening outside your jurisdiction. That is why I gave the example of me tokenizing Professor Bijsal's house. It's difficult to stop, particularly if no one knows, or only a group of investors. And I think that is a major problem here, that you do not see it. And of course, the technique itself in part is anonymous or pseudonymous. Although I know, because I have been talking to criminal lawyers on this topic as well, that it is possible to break into blockchains. It's far more possible than some criminals think. but still, the starting point it's anonymous, pseudonymous. It's difficult to find who actually owns a particular block because it's not a person, it's the computer. And you need to know who is behind the computer, who's behind the wallet. So my answer is, I can understand those governments because these developments are worrying and they are upsetting. They are definitely disruptive. But I think it's much better to follow and see what is going on and regulate than not do that, given the risks involved. So that would be, let's say, the policy choice. And that's why I think that the Commission in Brussels is following, I think, a path that I would support.
I see. So it kind of boils down to states will do whatever they can, but in fact, it will be at the risk of the consumer or the maker of these programs to bear.
At some point, a scam will happen. And then people are really angry and will ask questions and say, why didn't the state regulate this? Why wasn't there surveillance? And so on. And shouldn't you perhaps consider that as well and say, well, it's better to act beforehand than afterwards.
Very well. Thank you very much, Professor.
All right.
Thank you very much. So I would like to give the floor to Professor Başak Baysal, the Dean of the Kadir Has University Faculty of Law.
Thank you, Aslı. Thank you, Sjef. Thank you, Professor Van Herp, for this wonderful speech. It was really a projection into the future and for the digital world. And I hope to see you very soon in person. I don't know, in Maastricht or in Istanbul. We will be very happy to welcome you again in our university. Thank you again for this wonderful speech.
It was a pleasure, and I hope it was useful. Okay, thank you then. And now I have to, I'm afraid I have to rush off because immediately after this, I'm joining a roundtable at the University of Trento. You know, this is what you can do in the digital world. You can go from one capital to another in seconds. So all of you, I wish you, well, stay healthy. And I'm looking forward to seeing you in person soon. Bye then.
Thank you very much. Thank you very much, Professor Van Herp. And dear professor, dear colleagues, and dear students, thank you for participating. We are now closing the session. But of course, we continue, as always, the Comparative Law Seminar Series. So hope to see you again soon. Thank you very much. Have a nice day.
Bye then.